5 seconds. After this larger bench was constituted and the matter came up before this court, it was pointed out that criminal appeal number 463 of 1997 will remain pending during the course of arguments and till judgment is rendered in this reference, although the questions that have been referred to this court by the division bench had nothing at all to do with the merits of criminal appeal number 463 of 1997 but related to the general practice and procedure to be followed in hearing of criminal appeals. This court therefore passed an order on 22/3/2024 directing the registry to separate the record of criminal appeal number 463 of 1997 and send it to the appropriate bench for decision on its own merits and to register the reference under different cause title, that is, in re-procedure to be followed in hearing of criminal appeals. In paragraph 42 and 43 of the judgment, the Supreme Court had observed us. 42. This court in Pampapathy versus State of Mysore 1966 supplement SCR 477 had held that the High Court had the power to revoke the suspension of sentence granted under subsection 1 and 2 of section 426 in Criminal Procedure Code 1898 using its inherent power under section 561A of the CRPC 1898, where the accused were alleged to have misused their liberty while the sentence was suspended. Subsection 1 and 2 of section 426 CRPC 1898 are similar to section 389(1) of the present CRPC. It may be noted that in Pampapathy, the issue of cancellation of bail of a convict by taking recourse to section 561A CRPC 1898 arose because the second proviso, which now has been added to the subsection 1 of section 389 CRPC, did not exist under the earlier legal framework. However, since the second proviso to subsection 1 of section 389 CRPC now deals with the cancellation of bail, no inherent power would be required for cancellation of suspension of a sentence and bail granted to a convicted person during the pendency of the appeal at the appellate court. He has also pointed out Chapter 6 of the CRPC, which deals with process to compel appearance, referring to sections 70 and 71 of the CRPC and Form 2 of Schedule 2 of the CRPC. It has been argued that it only talks of warrant of arrest. Hence, if the High Court issuing the warrant of arrest had in its discretion directed in specific terms that the person against whom such warrant of arrest has been made should execute a bond with sufficient sureties for ensuring his attendance before the court at a specified time and thereafter, then it would be termed as a bailable warrant. However, if no such direction, endorsement, specification to take sureties has been made in terms of section 71 of the CRPC on the warrant of arrest, then the said warrant of arrest would be deemed as a non-bailable warrant. The persons who are arrested would be brought before the court who has issued the non-bailable warrant, and it would have an option to either send him to judicial custody, police custody, or release him on bail. Hence, if an appellate court during a criminal appeal issues a non-bailable warrant, the power to cancel it rests only with the appellate court issuing it, or if it is executed, the power to grant him bail lies only with the appellate court. The CJM or any other magistrate can only enlarge a person on bail if the appellate court, while issuing warrant of arrest, specifies that sureties may be taken in the event of his arrest, and in case no such specification has been given in the warrant of arrest, the magistrate is bound to commit such person to custody and without delay inform about its execution to the appellate court. Last but not the least in our appreciation of the law, section 482 CRPC stands in solitary splendor. It preserves the inherent power of the High Court. It enunciates that nothing in CRPC shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary, firstly, to give effect to any order under CRPC, words which are not to be found in the Code of Civil Procedure 1908, hereafter referred to as CPC. Ergo, the High Court can, while exercising inherent powers in its criminal jurisdiction, take all necessary steps for enforcing compliance with its orders. For salutary reason, section 482 CRPC makes the criminal court much more effective and all pervasive than the civil code insofar as ensuring obedience of its orders is concerned. Secondly, section 482 clarifies that CRPC does not circumscribe the actions available to the High Court to prevent abuse of its process from the inception of proceedings till their culmination. Judicial process includes compelling a respondent to appear before it. When the court encounters a recalcitrant appellant convict who shows negligible interest in prosecuting his appeal, none of the sections in Chapter 24 CRPC dealing with appeals precludes or dissuades it from dismissing the appeals. It seems to us that passing such orders would eventually make it clear to all that intentional and repeated failure to prosecute the appeal would inexorably lead not merely to incarceration but more importantly to the confirmation of the conviction and sentence consequent on the dismissal of the appeal. Thirdly, none of the provisions of CRPC can possibly limit the power of the High Court to otherwise secure the ends of justice. While it is not possible to define the concept of justice, suffice it to say that it encompasses not just the rights of the convict but also of the victims of crime as well as of the law-abiding section of society who look towards the courts as vital instruments for preservation of peace and the curtailment or containment of crime by punishing those who transgress the law. If the convicts can circumvent the consequence of their conviction, peace, tranquility, and harmony in society will be reduced to a chimera. Section 482 emblazons the difference between preventing the abuse of the judicial process on the one hand and securing of the ends of justice on the other. It appears to us that Section 482 CRPC has not been given due importance in combating the rampant malpractice of filing appeals only for squashing sentences imposed by criminal courts.